Welcome to Law Sessions. I am Jennifer Housen. In this law session on public law, we will explore the European Union, and in particular, we will look at EU law in the context of public law. Now, of course, I will start with the background, and certainly I will look at the institutions in this first segment, and that will be our initial focus. But the point here is that I don't want to be lost, is that when you look at EU law, you must understand the context for public law, and that is, what is the basis of EU law when you look at, for example, parliamentary sovereignty, and certainly when you look at a source of law. So sources of law, we see EU law as a source, and when you look at parliamentary sovereignty, we see that sovereignty does have some contemporary impact, not least from Britain's entry into the EU. So what I want us to do, first of all, is just look at the background and the institutions. Then we will look at the types of law, and then we will look at how the development has gone on over the next hour. Well, by way of background, when you look at the history of the EU and in the context of EC laws, so that what we're looking at is we have a group of countries coming together where the idea is that it is a single market. Never forget what the background is, because the whole idea was that it was supposed to have been an economic union. So if you look at this whole idea of economic union, then the idea that I am country A and you are country B, and I want my goods to move into your country and be sold freely without restrictions, without having to pay taxes like import duties and so on. Where did it all start? Well, started in 1948 with the Benelux countries, Belgium, Netherlands, and Luxembourg. We then move into 1952, where we have the European Coal and Steel Community, that's Germany, France, and Italy, coming together basically. The idea being behind it being, of course, he who owns the coal and steel rules the world. Or if I'm here watching you and you're here watching me, then it will be more difficult for us to start another war. So we get the European Coal and Steel Community, and of course, subsequently, 1958, we get the European Economic Community and Euratom. What we do have, of course, is that we get the ECSC expiring 50 years later in 2002. And so by and large, what we are discussing is really what occurs in the EEC and its development from that. Now by 1965, we get the institutions being laid out. And in particular, we have the European Parliament, the Commission, the Council of the EU, the European Council, and of course, the European Court of Justice, or as it is now called, the CJEU, the Court of Justice of the European Union. By 1972-1973, we get the UK coming on board, we get Denmark coming on board, we get Ireland coming on board, and even Norway, except that as soon as Norway joined, they then had to withdraw because, of course, there was a referendum in their country which opposed this. By 1981, we see Greece coming on board, and of course, if they knew then what they know now, maybe they wouldn't have been so eager to join. But in any event, 1981, we see Greece coming on board, and then 1985, Portugal and Spain join in, and we have seen since 1985 four major intergovernmental conferences, which have led, of course, to the Single European Act, the Treaty of European Union or the Treaty of Maastricht, the Treaty of Amsterdam, and the Treaty of Nice, all of which have acted as amending treaties to the Treaty of Rome. By 1986, then, we see the Single European Act, which is designed to deregulate the market, and it amended the EEC Treaty, and what it further did was to increase the internal market and address freedom of movement, and also increase the European Parliament's legislative power. One of the problems with the European Parliament as an institution over the years has been although it has been the only directly elected body, it has had no teeth whatsoever. So when you look at, for example, persons, electors, citizens in member states, it has meant that citizens in member states voted for the MEP, the member of the European Parliament. But the driving force had always been the Commission, the Council, and of course the EP took a backseat and had more or less a consultative role. So it was, if something was going to happen, that was significant in the European Union, the European Parliament did not really have any kind of power. So what we see with the SEA is that it introduced the co-decision and assent procedures, which of course meant that the EP had a little bit more of an input. And you will hear the term democratic deficit being bandied about. And it is this idea that we have the only elected body, or had the only elected body, not having a voice, particularly when you look at the legislative body. So the democratic deficit raised the idea of, when you look at the only democratically elected body, they did not have an input, meaning did the citizens who the European Union represented not have an input. By 1993, we have the TEU, the Treaty on European Union, or also called the Treaty of Maastricht. And it was set up to ensure that war did not emerge. There was economic stability with protection of free movement of goods and workers. And by 1995, we had some more joining Finland, Austria, Sweden. By 1999, the Treaty of Amsterdam, which sought to amend the original treaty and restructure the institutions of the EU and to move away from the narrow economic base. So again, the point was that it started as an economic union, going across borders, free movement of goods and so on. But what we get coming at this point was moving away from that narrow economic framework and pushing EU citizenship. We see a commitment to human rights and civil rights. And also, you start to see the penalizing of member states for breaching of its obligations, and also strengthening more the role and power of the European Parliament, not least in the appointment of the Commission, as well as the treaty sought to renumber the EC treaty. Now, it did also seek to simplify the co-decision procedure, except, of course, EMU, because the Economic and Monetary Union, because as you well know, the UK did not take that on board. By the time you get to 2003 and the Treaty of Nice, brought about enlargement of the community, strengthening the protection of fundamental rights, the monitoring of the CFSP in international situations, and certainly looking at revamping qualified majority voting for the ministers and the Council of the EU. And it also, for the first time, gave the European Parliament standing as what is called a privileged applicant. The way it used to work was that the EP could only bring or raise matters that were within its own prerogative. What you got now was that it was able to have standing as what is called a privileged applicant on the same basis of, say, the Council or the Commission. By 2004, there is huge enlargement. There is massive influx here of new countries: Cyprus, the Czech Republic, Estonia, Hungary, Latvia, Lithuania, Malta, Poland, Slovenia, and Slovakia. And of course, we then see enlargement with 2007 again, Bulgaria and Romania coming on board, with certainly some restrictions there. The most important impact, in my view, of course, is the Treaty of Lisbon. Now, the Treaty of Lisbon has come on board, renumbered again done a huge renumbering of the Treaty of Rome, further to the Treaty of Maastricht's renumbering. And what we get now, of course, is a situation where you have the Charter of Fundamental Rights. Please bear in mind the UK has not signed up to that. But the Treaty of Lisbon is where you now have a whole more comprehensive approach when it looks at EU and certainly aspects relating to the member states within the EU. Now, some countries are not allowed to use the euro because of the lack of economic sustainability in that country. Bulgaria and Romania, for instance, are under certain safeguards relative to accountability, corruption, and bribery. And when you look at going forward, the Copenhagen criteria, which suggests that there must be certain rules satisfied for any future enlargement, not least that there must be a stable democracy respecting human rights, the rule of law, and minorities, have a functioning marketing economy as well. They must adopt the common rules and standards and policy that make up the body of EU law. Now, when you look at the Treaty of Rome, which established the European Economic Community, the aim, as I said, was that it was economic in nature. Now, after the war and economic reconstruction, it appeared necessary. The idea was a creation of a common market. And when you look at the internal market, we're looking at a single market, economic integration, removing of custom duties. So you're looking at a common custom tariff. Now, there are 4 fundamental freedoms with which the EU are concerned: free movement of goods, free movement of persons, free movement of services, establishment, and capital. So the idea is you started off, or the EU started off, with this whole notion of economic union, monetary union, but of course excluding certain member states. And by and large, we see that the areas which they are concerned with are free movement issues. Now, the EU is governed by institutions, and there are, for all intents and purposes, 7 of them, as it were. And not least, we see Maastricht listing them out. And there are these: the European Council, the Council of the EU, or as it was called, the Council of Ministers, or just simply the Council. Then there is, of course, the European Commission, the European Parliament, the European Court of Justice, or the Court of Justice of the EU, the European Central Bank, the Court of Auditors, and so those then make up the entirety of the institutions. Now, without going into any great depth, I just want you to bear in mind that when you look, for example, at the European Council, it really wasn't an institution before Lisbon, because when you look at the European Council, these are all of the heads of the member state who generally meet maybe twice a year, and it is for them to drive policy. That is their role. So it is not, as I say, it used to be that they were not necessarily an institution, but based on Lisbon, it has become an institution. It now has a president. Now, the idea of a president, of course, is that he's not there as a true head of state. He is there, and of course it's Herman van Rompuy, the Belgian. He is the president, and he has been since December 2009, and he is responsible for preparing and chairing the meetings of the European Council, but he's not, for all intents and purposes, any sort of leader, as it were, for the EU. Now, the Council of the European Union, and as I said, it's usually to be the Council of Ministers, is the principal decision-making institution, and the Council should not be confused with the European Council, or indeed the Council of Europe. The Council of Europe has nothing to do with the EU. That's to do with the European Convention on Human Rights. Now, the Council is one of the 2 legislative bodies, and the other, of course, is the EP. And the Council is composed of 27 national ministers, 1 from each member states. And the Council is made up of that person or that minister dealing with that particular area at the time that a matter is being discussed. So let's say they are discussing agriculture. All the agricultural ministers will meet, and that is who comprises the council. The court, of course, is pretty straightforward. The commission is considered the guardian of the treaties. They're the ones who protect the EU's, they jealously guard the EU's position, whereas the council guards the member states' position. In a nutshell, that's who the main players are. And, this isn't an EU law lecture to the vast extent, but I would certainly suggest that you do look and make sure that you have some idea of these. The main ones that we will ever consider, of course, are the Council, the Commission, the European Court of Justice, and the Parliament. The Parliament has been given a lot more powers in successive treaties, and so they have pretty much come up to speed with the rest of the institutions. That for me is just background by way of the history and also in relation to the institutions and the players. We're going to take a short break, and when I come back, I want us to consider the types of legislation which come out of the EU immediately after the break.